Good morning, this is your Kelso Report for Tuesday, December 18th, and I'm your host, Clark Kelso. Our first case today involves the interpretation of a state long-arm statute in the context of a copyright infringement action. Then we have two California Supreme Court decisions, one involving attorney's fees in a disabilities case, and the other a death penalty affirmance. We close with an interpretation of the State Endangered Species Act. But first, let's begin with jurisdiction. The phrase, the long arm of the law, takes on special meaning in the context of personal jurisdiction and the interpretation of state long-arm statutes. The Ninth Circuit gave a particularly generous interpretation to Washington's long-arm statute in a copyright infringement action. In Washington Shoe v. AZ Sporting Goods, the court held that an Arkansas retailer is subject to personal jurisdiction in Washington under its long-arm statute, even though the Arkansas retailer's only relevant contact with the state was the claim that it willfully violated a copyright held by a Washington corporation. According to the panel, the allegation of willfulness, combined with the defendant's knowledge that the copyright owner was a Washington resident, was enough to satisfy the due process requirement that the defendant's actions somehow are purposefully directed or targeted at the forum state. As the court explained, Washington Shoe presented evidence that AZ engaged in intentional acts that willfully infringed its copyright, knowing that it would adversely impact Washington Shoe in the state of Washington, and knew or should have known both about the existence of the copyright and the forum. So, for the panel, that was enough to establish personal jurisdiction in a copyright infringement case involving shoes bought from China and delivered for sale in Arkansas. Now, stepping back just a bit, since a copyright owner can always bring its claim to the attention of alleged infringer by sending a cease and desist letter before filing suit, and any continuing violation at that point would be targeted at the forum state, the Ninth Circuit's holding essentially gives personal jurisdiction to the copyright owner's state of residence in virtually all cases, so long as the state has an appropriately broad long-arm statute. Well, next let's turn to an attorney's fees decision. In most cases, an award of attorney's fees can be made to either the plaintiff or the defendant, whichever party has prevailed in the litigation. Sometimes, however, legislatures have enacted one-way attorney fee provisions where only the prevailing plaintiff is entitled to recover attorney fees. These one-way provisions are often found in consumer or civil rights statutes where it is expected the plaintiff is suing a business or government entity. In Janke v. Lee, the California Supreme Court was faced with a possible conflict between federal and state attorney's fee provisions, one of which, the federal, authorized fees only to the prevailing plaintiff, while the other, the state, authorized fees to the prevailing party. The case involved claims under state and federal law for disability access discrimination, and the defendant prevailed and then sought attorney's fees. The trial court concluded that fees for a prevailing defendant under Civil Code Section 55 were mandatory and awarded $118,000. The Court of Appeal affirmed. The Supreme Court of California also affirmed, concluding first that Section 55 was properly interpreted as imposing mandatory fees to the prevailing defendant. The court then turned to the second issue in the case, whether an award of mandatory fees is preempted by the federal Americans with Disabilities Act. The court concluded that the ADA does not preempt this part of the state's attorney fee scheme for disability access suits, because Section 55, along with other aspects of state law, actually provides greater protection than federal law in certain cases, and the federal statute is designed to preserve state laws that provide greater protection. The fact that on this one issue, prevailing party versus prevailing plaintiff, state law provided less protection was not dispositive. Next, we have a death penalty decision. 22 years ago, the defendant was convicted of the first-degree murder of one Raymond Shield, with a special circumstances allegation that the murder was committed during an attempted robbery. The jury fixed the penalty at death, and the trial court sentenced the defendant to death. It took the Supreme Court 50 pages unanimously to affirm the death penalty. Next, an endangered species case. Once an administrative decision is final, and the time for any judicial review of that decision has passed, it can be devilishly difficult to secure reconsiderations of such a decision. The petitioner found out just how difficult in the 3rd District's decision in Central Coast Forest versus Fish and Game, which involved the petitioner's attempt to show that the 1995 listing of the coho salmon as endangered within streams south of San Francisco was erroneous. The factual basis for the claim was that the coho salmon actually never had occupied streams south of San Francisco, and so therefore could not properly be judged endangered within those streams. But the petitioner did not challenge the listing after it was made pursuant to a writ of administrative mandamus. Instead, some 9 years later, the petitioner filed a petition to delist the coho salmon. However, the 3rd District rejected the petition on procedural grounds, holding that a petition to delist a species may not be employed to challenge a final determination of the Commission. In particular, the court explained that the delisting procedure is not a means by which new information may be submitted on the merits of a prior final determination. Instead, delisting is a process by which evidence is submitted that a species is no longer endangered, not that it never was endangered. Since the petition was procedurally improper and the 1995 determination was final, it appears the petitioner is out of luck. And that's it for today's Kelso Report. Have a great day in the law.